Hi, everyone. Hey, it's Tom James and Bobby Raitt again, coming to you from First Rate Law. And this is episode 8 of our podcasts. And we're excited today. We have a really good topic for you. And so the topic is, what are the common questions that we get from our clients? And those common questions are things like, do I have a case? Or if we tell you you don't have a case, why is it I don't have a case? Who's going to pay my medical bills? How long will this process take? We're going to go through all of that now for you. And so, what we're going to start with, right? What we're going to start with is probably the number one question that we get, and that is, do I have a case? So, as you know from prior episodes, right, we have extensive experience in representing people over the last, like, we have a combined total of 50 years of experience of helping people who've been injured due to someone else's fault, right? Making sure that they get recovery, making sure you get your medical bills paid, making sure your family's taken care of, depending upon the severity of the injuries. And so we have quite a bit of knowledge to draw from to be able to answer these questions. And so the question of, do I have a case? Well, it comes up obviously in different scenarios. So there could be an auto accident. There could be a slip and fall, dog bite, construction accident. You could have been electrocuted, during a pole, being by a pole, walking by a pole. All of these cases we take. Now, I will tell you the nuances of it are that it really depends on what type of case, the types of injuries, and the circumstance as to whether or not someone has a case. For example, an auto accident. The things that we look for, number one, who's at fault for that auto accident? And that collision. Obviously, if you are the primary person at fault, more than 50% at fault, that's certainly going to affect whether or not you have a case for personal injury. However, if your concern is getting your medical bills paid, then you could still have a case in that scenario against your own auto insurance company if they're not doing what they were supposed to do. Again, these are all one-off scenarios. We need to know, we need to hear from you so that we can gather those facts to make that call for you and to give you those suggestions. If it's a slip and fall injury, do I have a case? Again, we have to look at whether or not the facility where you fell, or a person's house where you fell, whether or not they're responsible for whatever made you fall. Was it uneven concrete? Was there some substance on the ground that you slipped on? Those types of things, in addition to looking at the extent of the injuries. Other things with regards to construction sites. Construction sites are very complicated because you get into issues about, well, you can't sue your own employer for personal injuries. However, you might have an action against another subcontractor or against the general contractor. It's all very fact specific with regards to each case. So, absolutely. I mean, that's why we give out our number all the time, 866 rate law. So you can give us a call so we can go over all of these things. How about if you give us a scenario, Bobby?
Well, it's funny as you're talking, I'm realizing so many clients, feel they've been injured, therefore they have a case. And it's obviously dependent on the type of case. In other words, how they were injured. Was it an auto accident? Was it on a construction site? But the truth of the matter is, just because you're injured and just because you have pain doesn't mean we have liability or negligence against a party. Depending on the type of case, doesn't mean you might necessarily meet the threshold. In automobile accidents, for sake of example, there's an objective component. There is a limitation component. In other words, it has to limit the ability to lead the life that you led before. So, bottom line, just because you're in pain, to answer that question, you don't have a case. These other areas are where our expertise comes in to best advise you on how to move forward. And that goes to the other question we get so common, Tom, is how much is my case worth? There are so many factors that go into how much is your case worth, but I like to almost joke to people in the beginning, it depends what the insurance company thinks it's worth, or it depends what a jury thinks it's worth, or it depends what the defense attorney thinks it's worth. Because one thing a lot of people don't think about when they're injured is who's going to pay and is there a limit? And yes, in most cases, there's a limit to that insurance that's going to cover your damages, that liability coverage. There's usually a limit, right? So that's one factor. But then you just look at your injury, you look at who you were before and how it affected that person from before. I also explain in auto accidents a lot of times, if you're the type of person that sits on the couch all day and watches soap operas and you break your leg, you're going to have a lot different experience in a claim or a lawsuit than the professional athlete that breaks their leg in an auto accident, because it has affected your life a lot differently and therefore has more value. So, how much is my case worth is an impossible question to answer in the beginning close to accurately, because you have to see how your injuries manifest themselves. You have to see what the insurance involved is. You have to see how much are you going to treat and what are the tests going to show and how is it going to affect your life and what were you doing before. Is it going to affect your ability to work, which is a huge factor in all these cases? So how much is my case worth is a tough one, but you can see with our experience, we're going to make sure that we check all the boxes to get you what your case is worth. And in the end, we'll know that, right?
Yeah. And, building on that, be very careful about going online and typing in your information into these websites that say, hey, we'll tell you what your case is worth. Right? There is no software that'll do that. There is no website that accurately does that. What it is there are other attorneys that do what we do, that gather your information and then they want to call you and then try and sign you up. So there is no software that does that. But the next question, kind of building on there, once we get to the point where, yes, we think you have a case, we're investigating it, the next most common question we get is, man, how long is this going to take? Right. And trust me when I say we don't want this to take any longer than it needs to either. And that is because, right, there's no incentive for us to string this out any longer than it needs to be. If we could get you full recovery within 4 weeks, we would absolutely get you full recovery within 4 weeks. But unfortunately, it doesn't work that way. There's a lot of analysis that goes on. There's a lot of paperwork that goes on behind the scenes. When I say behind the scenes, it's things that we're preparing and sending to the other person's insurance company, right? Whether it's a restaurant's insurance company or an individual or a trucking company. And so it takes time, right? It takes time to gather medical records. It takes time to gather medical evidence. If you'll recall from our prior episode, we talked about the importance of going to the doctor, right? Of creating that paper trail so that everyone can understand your injuries, both that they were caused by this event, as well as the extent of the injuries and what it's preventing you from doing. So all of that becomes very important. However, right, we can't gather all of that medical evidence within a couple weeks, and it certainly isn't typically in a couple months. I would say on average, we can get some cases settled within about 6 months. So those are cases that generally, either involve a death because there isn't a ton of medical records, or it involves people who get treatment only for a short time period, and then we're able to get some nominal recovery for those. But for the most part, if we have to file a lawsuit, that lawsuit itself, right, from the time we file within the court system to the time it's dismissed, whether it's through a settlement or a jury trial, that's going to take a year, year and a half, 2 years. And that is if there's no appeals. I'm going to tell you, one of the worst situations I had to deal with a client was a case that lasted 9 years. 9 years. That is unusual, but there were
It was
multiple
worth the
appeals.
wait. It was worth the wait.
It was worth the wait, right? We ended up getting a very large verdict, a $14 million jury verdict. But it was a long process, right? And there were multiple appeals, all of these things. So I guess my parting comment with regards to how long does this take, we do our best to get this wrapped up for you, and we fight for you to get it done as quickly as possible. However, there are certain things that hold us back from being able to do that, and we're relying upon hospitals and facilities to get us those records to support your injuries and prove all that evidence too.
And that kind of leads to kind of an offshoot of a question that we get in some form all the time. And that is, who are we suing? Are we filing a lawsuit and that type of thing? It became very apparent to me as a young attorney that the general public thinks attorney, lawsuit, right? That it just goes hand in hand. And over the course of our careers, the amount of times we file lawsuits versus settling without a lawsuit has changed. But one thing has been consistent: we certainly don't have to file a lawsuit in every case. And most recently, over the past few years, we probably file lawsuits in only a quarter of our cases, or about 20 to 25% of our cases, because we're able to resolve it without a lawsuit before we ever come to that point. Obviously, if we don't have to file a lawsuit, the case, the claim is going to be a lot quicker. Tom mentioned that once you file a lawsuit, it can take a year and a half. If we don't have to file it, we're settling before, and that's where that 4 to 6 months comes in. And as far as who we sue when we get to that point, well, we're suing the entity that caused your injuries. And we get a question a lot from people. They're like, "This is my neighbor." If it's, say, it's a dog bite, or my family member was driving the vehicle. I know that they were at fault, but obviously I don't want to sue them. Once you get to the point where you realize we can't settle this case without a lawsuit and we're all on the same page, because one thing we pride ourselves on is including our clients in the conversation, letting them make the call with the advice that we give them. So if we're telling them, look, the insurance company in this case, Mr. Jones, they're giving you a real lowball offer. It's not what your case is worth. It's not what your injuries and impairment should equate to. We'd advise a lawsuit. Once they agree to that, we explain the process to them. And that process includes having to actually name the individual or the company in the lawsuit. In other words, we're not naming their insurance company, even though we've explained to the client it's the insurance company that's going to give us the money eventually. We have to actually sue and name the individual. So if you have a family member and they were at fault and their insurance company is not giving you what we think is reasonable compensation, and you want to file that suit, yes, we have to name your family member, but we all know for sure we're not going to go after them individually to their assets and things. We're going to stay within their liability limits on their insurance policy. And so the who we are going to sue depends on the case, obviously, but in the end, it has to be an individual or a company. It's not the actual insurance company.
Yeah, maybe that depends on the family, though. Who knows, right? Like, if my brother ran me over, I'd be like, oh, let's go after him fully, right? Forget about his insurance company.
But how often do we hear, I don't want to go after them. I don't want to hurt them. I don't want to make them mad. And that's understandable.
I mean, I would say the majority of the time, right? No, I mean, nobody wants any harm to come onto anyone else, right? But at the same time, if you've been harmed, it's only fair that you're compensated for those harms. And so, absolutely, 100%. Now, here's an interesting question that we get, and we get this question a lot more than I would have anticipated prior to becoming an attorney over 20 years ago. But we get the question of, should I go back to work? Or, right, the follow up question, if I go back to work, how is it going to affect my case? So, pretty much, I would say, if not every client that we originally sign up, when we sign up a client, they're disabled from working to one extent or another, right? Or disabled from performing certain activities, and so it becomes a question of, like, when I am able to return back to the activities, how will it affect my case? So, I guess number one, though, asking us whether or not you should go back to work, we're not the best person to answer that question, right? We do not answer the question of, should I go back to work? That is a question that needs to be posed to your doctors. And your doctors will tell you whether or not you're well enough to go back to work. And if your doctor says, yes, you are well enough to go back to work, then absolutely, you should go back to work. Or return back to the activities, whatever they were, with regards to those restrictions. Um, but here's the question we can answer. Now that I've been returned back to work and my doctors have said I should give it a shot or go back in a limited capacity, how will that affect my case? And it actually, right, surprisingly for most people, it helps your case. Now, it does potentially reduce some damages that we can claim, but it helps your case because it builds credibility. Most people who are injured in collisions or slip and falls or from a dog bite get better over time. So it adds credibility to your case that as time goes on and as the treatment becomes effective, that you're becoming better and you're returning back to normal activities that you had before. So anytime someone kind of bucks that, like all of a sudden they're not getting better, right? Even though all the doctors are saying we're doing everything right, the surgery we performed, it worked, it was successful, but then the patient is saying, well, I'm not better, I'm not any better. That actually is a red flag for these negotiations that we go into, and insurance companies start thinking that you're faking or that you're exaggerating injuries or exaggerating the extent of impairment. So, when you do get better and return back to work and activities, it adds credibility to your case. Now, where I said it kind of decreases things that we can ask for, well, in most every personal injury case, whether it's, car crash, slip and fall, dog bite, if you are unable to work for a certain time period, there tends to be a period of time where we can ask for those lost wages in the personal injury case, right? There's certain circumstances where we can't, but for the most part, we can ask for lost earnings, lost income. And in those situations, it just reduces what we can ask, but it really doesn't change anything from your perspective, right? Maybe it lowers the value of that part of the lawsuit, but you're already earning the money, so you're not actually net negative. So, and that's one thing I remind people of all the time. They're like, well, won't it reduce the value of my case? And we're like, well, I guess technically it does a little bit, but for your personal assets and your bank account, it still stays even because you're bringing in that money through actually working. So that is a great question. I love answering it for everybody. I think it surprises people when they find out. Right, number one, I won't tell someone to go back to work or not go back to work. I tell them to go back to their doctor and ask. But then certainly we'll provide a full explanation of how it affects any case.
Well, you know why it surprises? Because it surprises people because what we generally get, Tom, is my husband says I can't go back to work because it's going to ruin my case. Or my friend was off work for a year and it's only been 7 months for me and he got a lot of money. Will this hurt my case? And what I say to people is not that I won't answer the question necessarily. What I say to people is I never, and this is 100% true, I have never told a client to stay off work for their case. What I tell my client when they ask me this question is ask your doctor. If your doctor feels you can't work and you don't feel you can work, then don't go back to work. But what Tom said is 100% true. If you, in the back of your mind, even are staying off work only because you think it's going to make your case look better, 9 times out of 10, somewhere along the way, whether we're sitting in a deposition because we're preparing for trial, or whether the defense attorney is evaluating you in a deposition, which they always do, and then go back and report to their people, it's going to look bad if, come on, you could have gone back to work and you really don't have a medically based doctor disability to keep you off work, right? So 100% don't stay off work for your case. Make sure you're coordinating with your doctor, because if your injuries are to the point where you are disabled, then staying off work is medically justified and it will look valid, and that will be reimbursed to you. But the corollary to that is you're probably going to get hurt in negotiations if you're one of these that are just sitting home waiting to make money and you could have gone back and tried to work. Because part of it too is just because you're back to work doesn't mean you're all better and doesn't mean you can do the job the way you did it before. I mean, the best case scenario is if you feel that you can't do the job, say your doctor isn't giving you disability, you want to go try, we encourage you, go try and talk to your boss about how you can't remember things like you used to because maybe you suffered a traumatic brain injury or a concussion, or you can't lift the boxes like you used to because maybe you have a back injury, and then it's documented and then you look great despite the fact that you're having that pain. You're trying, and that's the best situation, that's the best client.
Yeah, and that's one thing too. And I know we're staying on this topic, but it's an important one, and it's probably one of the more common questions we get. Right? When should I go back to work? Should I go back? But I've had plenty of situations where a client's been disabled for maybe 6 months, and then the doctor says, "Well, hey." Well, let's just give it a shot, right? Let's see if you can return back to your job. But I'm going to give you a 5 pound lifting restriction or a 10 pound lifting restriction. They end up, they're like, okay, great. They go back to work, they give it a shot. But as they're there, they're noticing, right? Because they're having to stand on their feet for 4 hours at a time. or they're having to sit and still for 4 hours at a time. Maybe they weren't able to get a sit stand desk or accommodations. That all of a sudden it's increasing the pain. And then they go back to their doctor maybe a week or two later and say, hey, I gave it a shot. I gave it my best. But standing on these floors and they won't give me any accommodations, it's excruciating on my back. The doctor will do a reevaluation and say, hey, look, I see those spasms are back. Hey, look, and then they hit those markers and they're like, no, we gave it a shot, but I'm going to take you off of work completely now and give you a little more time. Let's give it another 2 months before you give it a shot. So that happens all the time. And actually, Ed, that's actually really helpful when people go back because, as Bobby was mentioning, at the deposition, when litigation starts, there's always a deposition. And the deposition is the time when the insurance company's attorney gets to ask you questions about your injury and your case. And inevitably, they always ask, why aren't you working? Well, I've been disabled. All right. Well, have you even tried to go back to work? No, I haven't tried. Well, how do you know you can't do your job if you haven't even tried? And for some of my clients, they're like, he's right. Maybe I could try. I never have. But in the scenario where you do go back, you do your best, but standing for 4 hours is too much. Then you go back to your doctor, you did give it a shot. And again, it's all about adding credibility back to the case, believability back to the case, because that is ultimately going to be the biggest thing, right? Once we add credibility to your case and they believe it, they being the other side's insurance company, we're going to be able to do something great for you.
Yeah. And let me talk about another question that's kind of an offshoot of the medical situation, the disability situation. And this, I'm just going to talk about it exclusively with auto accident cases because, in auto accident cases, you have no fault insurance. As far as disability, as far as staying off work, wages are built into one of the benefits you get. But the biggest question we get as it relates to your no fault benefits and ultimately your case is, who's paying my medical bills? And when we explain that it's correlating your auto insurance with maybe health insurance that you have, and they're there as long as it's reasonable and necessary and related to your accident to pay your medical bills. We now have this other issue because not everybody has quote unquote unlimited benefits like they used to with respect to, 10 years from now, if you're still treating for something that's clearly from the auto accident, they pay it. But if you don't have that unlimited anymore, there's a monetary or a number that is the cap, say 250,000 or what have you. But the question I get so much at the beginning of the case, usually, and obviously comes up at the end too, is let's say I settle my case for my injuries. Let's say I settle the damage case. We call it commonly in auto the third party case for your pain and suffering, the damages, how you've been affected, what injuries you have, and that's the third party case. You also in auto have what we call the first party case or claim, and that's for your no fault benefits. So I just had someone today, they're looking over our fee agreement, they're considering signing up with us, grave injuries, and she's already treated a ton because the accident happened a while ago, but she needs treatment indefinitely into the future. Her question was, if and when we settle my case for my injuries on the third party case, as we're calling it, how does that affect my medical bills? Will they still be paid? And we explain to clients two separate claims, totally, for the most part, unrelated as to whether you have the right to get those medical bills paid. And that is settle your case for your compensation for your pain and suffering. You still have your claim, we call it the first party claim, with your auto insurance to pay those medical bills, to pay the wages. It's unaffected by the fact that you settled your third party case. And so that's a big one for people because they don't understand. That's a benefit if you have unlimited benefits for life, as long as it's reasonable, necessary, and related to the accident.
Yeah. And so, for the auto collisions and auto accidents and a truck and motorcycle with the car, all of that stuff, um, definitely, right? We have that first party claim. It becomes very important for paying medical bills. But what about the rest of the folks, right? So I'll answer that with regards to, your injury came from a slip and fall or a dog bite or pretty much any other injury type of event other than auto accidents, because those are unique in the way that insurance is handled. But when you're dealing with these other types of cases, and I mean, who pays those medical expenses? Well, you need to get that treatment. And until the case is done, we generally don't get any money from the other person's insurance company or the restaurant's insurance company. So hopefully, right? Hopefully, there is some sort of health insurance, whether or not you're using your private health insurance, those things like Priority Health, Blue Cross, or those are provided through employers, or you buy it through the marketplace. Also Medicaid, there's Medicare, there's a number of other options, but you're going to have to use your own health insurance for the majority of that treatment. Now, some doctors, some medical facilities will do things on what they call liens, which means they'll wait to get paid until after the case is done, whether that's through a settlement or a jury trial. So there's certain circumstances where that'll happen, but those are fewer and far between compared to the people who have some sort of health insurance to go back on. Now, I will give everybody a warning, right? Whatever these health insurance companies pay, right? Whether it's Blue Cross, Priority Health, Medicare, Medicaid, they're going to want their money back. And they have a right to get their money back for the most part. So where does that happen? Well, that happens through our claim, right? So earlier, right, we answered the question, how much is the case worth? What are the things that we can go after in these cases? Well, one of the things that we can go after is we can go after the defendant and their insurance company to get your medical bills paid. If those were already paid by another entity, then we get the money from that insurance company, and then we reimburse the health insurance company for whatever they paid. So,
And not
um,
auto. And not
yeah,
auto. Not auto.
and again, what I'm talking about is non-auto. Everything Bobby talked about was auto related. It sounds complicated, and maybe it is if you don't do this every day. But I mean, literally, this is part of our practice. We do this every single day for our clients, and we're pretty good at it.
And that's why they should call us. It's funny, this episode really speaks to what I tell anybody and everybody. Call us. Any questions, call us. We don't charge you to talk to you. Hopefully, we give you information based on our 50 plus years of combined experience. You can tell from this episode, we receive a lot of questions and a lot of the same questions, and we're pretty well versed in various areas of personal injury law. So if you have any questions whatsoever, pick up the phone, dial 866-RATE, R-A-I-T-T, LAW, L-A-W, or go to our website, www.firstrate, R-A-I-T-T, law, L-A-W.com. Thank you.